Hi there, folks. It's Christine here again, wanting to talk with you about elder and dependent adults and some of our mandated reporting responsibilities with this population. So first, want to define elder adults under the Welfare and Institution Code section in the state of California. An elder is defined as a person 65 years of age or older. I just had a little argument about this with my mother-in-law, who is 79. She saw me preparing these slides and said, "Hey, elder is a state of mind." And I want to also acknowledge the ways in which certain terms can be viewed in legal ways, and also some people can experience them to be pejorative. Some people view the word elder with a great deal of reverence and respect. There's a lot of different cultural ways that we understand these terms and these words. So I just want to acknowledge that as we get into this content. And this is how it's defined in California. So dependent adults are also defined in both the Welfare and Institution Codes, that's W&I, and the Health and Safety Codes in California. A dependent adult is someone between the ages of 18 and 64 with a physical or mental limitation that restrict their ability to carry out normal activities or protect their rights, including but not limited to persons with physical or developmental disabilities or whose physical or mental abilities have diminished because of age. Under the Health and Safety Code, dependent adults include any person between the ages of 18 and 64 who is admitted to an inpatient 24-hour facility. And so that's important to note as well. Adult Protective Services has both preventative and remedial activities performed on behalf of elders and dependent adults who are unable to protect their own interests and or are harmed, threatened with harm, or have caused physical or mental injury due to the action or inaction of another person, as a result of physical or mental injury caused by this other person, or due to their own action, quote, as a result of ignorance, illiteracy, incompetence, mental limitation, substance abuse or poor health, lacking in adequate food, shelter, or clothing, exploited of their income, or deprived of entitlement due to them. I want to acknowledge that legalese and legal terminology will often phrase things in ways that we might not say them as social workers, and referring to someone as ignorant or incompetent, for example. But I just want you to understand how it's defined in the law. The goal of Adult Protective Services is to provide intervention activities directed towards safeguarding the well-being of elders and dependent adults who are suffering or at risk of abuse or neglect, including self-neglect. And, if depending on what order you're watching these in, I've also talked with you about child abuse reporting. And the notion of self-neglect is something that is unique to adults and older adults, dependent and older adults. We don't assess self-neglect in children because by nature, under the law, we consider them to be dependent, right? Dependent on adults to provide their care. But when we're looking at adults, the notion of self-neglect is part of what we may talk about. So, want to appreciate Dr. Brian Kemp's work from UC Irvine in helping us to unpack some of these terms that are used in the law and also can be used in day-to-day conversation. So I want to be really clear about what these terms are and how they're used. That people have the right to make choices that we might not agree with. I know that's maybe an obvious statement, but when we come into thinking about the purview of exceptions to confidentiality and mandated reporting and getting systems involved in people's lives, it's important to understand where the role of individual choice, can live. So this brings up notions of autonomy, vulnerability, capacity, and undue influence. So I'm going to unpack each of these a little bit. So autonomy is someone's right to govern themselves. It's the highest principle in legal, psychological, and medical issues, right? A person's autonomy. This is currently a very hot topic in terms of talking about people's autonomy to decide whether or not to become vaccinated, for example. For some people, they are immunocompromised and a vaccination is not healthy or appropriate. For others, it is, it's a personal choice, right? And so this notion of autonomy, it means that you have the right to make your own decisions as long as you have the capacity to make them and you are not unduly influenced. So this is a way that these terms kind of become mutually interrelated in this context. So you can choose to live this way, doing the barbells, hitting the gym. I might say, woo, that's pretty heavy. That's not my mother-in-law, by the way. I can talk more about her, but I probably won't. Or you can choose to live this way, right? So people can make choices in their lives about how they want to live. And I'm certainly not saying these are the only two choices, but I'm just trying to be really clear that, there's ways that, people can make choices in their lives about how they go about their day-to-day activities and, what it means for them to be comfortable in their space, in their home, if they have a home, and how they like to spend their time. And sorry, Nika Paprika is my dog, and she has something to say about this. So sorry about that. So I want to also acknowledge, when people may be preparing legal documents like their will, for example, that there are questions about, what kind of influence a person might have or who they might decide to leave things to, right? They may have a tremendous amount of money and decide to give it to someone they recently met. And their adult children might say, well, what about me? And why are you giving it to this strange person? Or you just started dating this person and you barely know them and you're, leaving them the house. And what's that all about? Well, people have the right to make their own choices and decisions. Again, so long as they're competent to do it, they're not at the risk of undue influence, right? Those are some of the things that we need to think about. So as long as you have both capacity and you are not duly influenced, right? Those are the things that the system might take into account and, legal folks would take into account around trying to understand whether certain actions are a sign of abuse or neglect, including self-neglect, or if they're just choices that maybe you don't agree with, right? And that's important because, as I've talked about in other lectures, the role of our personal opinion and our own personal values and ethics, it's not like we can actually check those at the door, right? We might say that, but the truth is that you bring your thoughts, your feelings, your beliefs, and your prejudices, and all of those things, you bring them with you. So when we're thinking about what it might mean to whether something is abuse or neglect, it is important to have some bright lights and some bright lines around what that means. So if you lack, if you lack capacity and you are not, and if you lack capacity and you have undue influence, you could be subject to abuse from others or neglect from yourself. Okay, just to keep it really, really simple. So thinking about vulnerability. Vulnerability is really any condition that's severe enough that another person could use it to unduly influence you or take advantage of you. A lack of capacity is an example of a type of vulnerability. And most vulnerable conditions are diagnosable disorders. These could be mental health related disorders. These could be medical conditions. Could be a traumatic brain injury. It could be Alzheimer's. It could be acute psychosis. It could be severe depression. Again, not everyone who has these disorders will always present as being vulnerable. I don't want to conflate those, but I'm sharing some examples of some conditions that you might come across that impact and that can contribute to a person's vulnerability. Undue influence is when people exert inappropriate influence over a vulnerable person to change their behavior or decisions. Okay, so for example, an adult child might be exerting inappropriate influence by maybe making their older parent feel guilty or saying, I will live here and take care of you and take you to your doctor's appointments, maybe for someone who, lacks mobility or needs support to get around, I'll do that for you, but you need to leave me the house in your will, or you need to pay me, $3,000 a week. Because, my time is really valuable and I lose income when I can't, those kinds of things that could be considered undue influence. So under the law, capacity is defined in the probate code in California 812. When we look at capacity, there's two things we need to think about: a person's ability to understand and a person's ability to appreciate. So understanding can be assessed by having a person restate key facts regarding the decision to act or process information adequately, right? So is this about, did they understand what they were signing, or did they understand that they were expected to sign? Do you know what I'm saying? The difference between, like, there's the line, I'm signing my name, right? I understand that's the line, versus I understand what my signature on that line, indicates, right? What am I bequeathing? What am I agreeing to, right? Those are different things. And then one's ability to appreciate requires the ability to relate information to one's own circumstance, identify consequences to self and others of their decisions, and weigh risks against the benefits to self, right? So a person's ability to kind of think through the pros and cons, and and relating that back to oneself and their circumstances, right? So a person who may be subject to undue influence may appreciate the pain that their child is in if they make them upset, or they might appreciate that their day is going to be very fraught with yelling if I don't do what they ask me to do. But that's different from appreciating, if I sign this thing, or if I make this choice or say yes to X, Y, or Z, what will that mean for me, right? Will I still have access to my friends? Will I still, have food? Will I, whatever it might be. So it's important that both understanding and appreciation are present. And I'm letting you know this just so that you kind of have some background information about kind of how the Adult Protective Services system kind of looks at these issues, and for you to kind of understand, as a mandated reporter, in your roles, you may be assessing for some of these things, right? And what you find in your assessment may indicate whether or not you need to make a report in the first place. Okay. I do want to say that if you have, we'll talk about reasonable suspicion again, but if you have reasonable suspicion, I want to just underscore that you do not have to have gone through all of these assessments in order to make a report. But, if you want to be informed about what it means for a person, for example, to be engaged in self-neglect, that needs to be predicated on something, right? If you have that assessment or suspicion. So decision-making capacity in the probate court addresses the inability to give informed consent to medical treatment. So people who lack decision-making capacity may have a conservator or someone else who would consent to treatment. This could be consent to psychiatric treatment, to medical treatment, consenting to services. We talked about informed consent. So sometimes people do not have the decision-making capacity. And as I talked about in that lecture, someone who lacks legal decision-making capacity, we may seek their assent, but the consent may come from, someone who is a conservator, for example, someone else who can consent on their behalf legally, right? Because the person may not be able to fully understand the pros and cons, the implications, the risks and benefits, may not fully understand the landscape because they may have limited decision-making capacity. And probate court 811 defines deficits in mental function. So if you want to refer to specifics, you can do that. Understanding details in the law. I just want to say around scope of practice. We often work within systems that are informed by the laws. And so I, mention where you can find things in the law for those reasons. I think it's good for us to, be aware of where things come from, and also to, to refer to those spaces. But in terms of interpreting the law, just to be clear, that is outside your scope of practice, unless you have, giving legal advice, that kind of thing is outside my scope of practice, and is outside of yours, unless you also have your Juris Doctorate and you are a legal professional. Okay. So capacity is not the same as a diagnosis, right? So someone could have dementia, an intellectual disability, or mental illness. A diagnosis cannot tell you a person's capacity, right? Capacity must be individually assessed. So it's very important to understand, as I mentioned before, that you not just say, oh yeah, they don't have capacity because they have dementia, or oh yeah, this person has schizophrenia. Nope, they don't have capacity. That is very disrespectful ethically, and legally, it also doesn't meet the terms. It's not the same as a person's IQ, and it's not the same as competency. Competency is a legal term, whereas capacity is a clinical term. Okay, so if we say an adult lacks capacity, we'd need to then back that up with, how do we know? We've assessed that based on what, and not reliant solely upon a diagnosis. So neglect by self or others includes things like lack of basic body or personal hygiene, lack of adequate food or water. Again, this can get into spaces where we want to be mindful to not conflate poverty with neglect. And so, when we're assessing for that, it's, for persons for whom they have the resources to secure these things and don't, if that makes sense. Let's talk if it does not. Lack of medical aids like glasses or walker or wheelchair, hearing aid, dentures, medications, etc. When those things are needed to engage in their activities of daily living and a person does not have those, that can be neglect. Lack of clean, appropriate clothing and linens. For victims who may experience dementia, if they're left alone or unsupervised, that can constitute neglect. People who may be bedbound, who are left without proper care in terms of, changing linens and making sure that they are receiving food and toileting supports. The home may be cluttered, filthy, in a state of disrepair, or having health, fire, and safety hazards, right? And so, people who may experience difficulty with hoarding, sometimes that kind of behavior or clutter, is a person's personal preference, and people can do that. But the point at which it becomes a safety hazard, a legal hazard, it blocks your ability to take care of your basic needs. Or if there are rats or there are other infestations that cause public health related concerns, mold, those kinds of things, fire hazards, maybe animal food and feces all over the house, urine, that kind of thing, those become public health concerns, right? So the difference between maybe a messy house and someone who may be hoarding and having a lot of things all over the place, but there's a pathway out and it's not physically unsafe versus some of these hazards I mentioned. The home may lack minimum equipment and facilities like a stove, refrigerator, heat, cooling, and working plumbing. Again, I want to recognize the privilege from which that term is phrased in this country. For people who have a home and have a space to live in, an indoor space to live in that has these things, that they're not working or not available. Animal hoarding can also be a sign of neglect. Now, some people have a lot of cats. My sister-in-law has 7 cats. And when she got the 7th, I was like, okay, we need to chat about how many more you're going to have. And she loves cats and, that's a whole thing. But, hoarding versus, enjoyment of animals and having the space for those animals, are 2 different things. But I think, one of the key indicators can be making sure that both the animals and the humans have safe spaces to be in, to coexist. So it's not about the number, but it is about kind of the behaviors and the other things around it, if that makes sense. So financial abuse includes lack of amenities that the victim could otherwise afford. They may voluntarily, quote unquote, give away inappropriate financial reimbursement for needed care and companionship. I gave an example of that earlier, right? Charging $3,000 a week to pick up your medications at the pharmacy and cooking meals, that kind of thing. The caretaker has control over the money, but is failing to provide for their needs, right? So there may be arrangements for a caretaker, which sometimes is also a family member, to pay the bills and pay the mortgage or, pay insurance. And those are in arrears. And maybe the caretaker is instead using that money for themselves instead of using it for its intended purpose. The caretaker may be using victims' financial resources again for their own needs, and the victim assigned property transfers, power of attorney, wills, etc., when unable to comprehend the transaction. So again, really needing to assess for that. Physical abuse includes inadequately explained bruises, welts, cuts, sores, and burns. Pressure or bed sores can be particular to folks who may be bedbound or have to spend a lot of time in a reclined position. I also want to acknowledge the ways that medications can be used as a type of restraint. So instead of maybe, and some people are also restrained by handcuffs, by, you know, other means of literally chaining someone to the bed so that they don't wander. That can get complicated in families that may not have a lot of resources to help watch and adequately supervise. And so it's intended to help keep the person safe. And there can be a line between that and kind of an imprisonment and a form of abuse. So that's important to understand. Medications can also be used this way as well. I want to say, excuse me, that medications can be used this way with children as well, really with anyone, to calm them down. Sometimes, kids, for example, may be given Benadryl as a in congregate care settings. We've seen a lot of abuses of the ways that medications are used, or other sedatives to calm someone down who's screaming or who is very active, or sleeping medication, things like that. So it's important to recognize that medications that are being used other than directed and other than prescribed can be a form of physical abuse. Psychological abuse includes caretakers who violate the victim by restricting visits and phone calls, like doesn't want other people speaking to them or visitors in the home. The caretaker may be violent, aggressive, controlling, addicted to substances, and or uncaring toward the victim. Now, I want to say that not all caretakers who may be addicted to substances are going to be psychologically abusive, but when those behaviors may also manifest in some of these other ways and or contribute to, like we talked about with children, acts of omission or commission, right? So if a person is inactive in their addiction and maybe while they're high or under the influence, they fail to take care of the other person, that could be a type of neglect, for example. And some people who may be under the influence may be increasingly violent or aggressive. And so to be clear, saying that a person as a caregiver is active in their addiction is not a justification for that behavior. It can be a complicating factor that can help us to understand what it might mean to support the family, though. When a victim of elder abuse lacks the ability to resist undue influence due to a mental capacity like dementia, a conservatorship may be appropriate. And getting into all the details of that is really beyond the scope of this, but information is available at the Public Guardian website, and I'm sure you'll be learning more about this in your courses related to working with older adults and dependent adults in public policy and the like. Isolation is intentionally isolating a person from social contacts like phone calls, visits, and receiving mail. Some people are kind of loners and don't really like to be around a whole lot of other people, but they definitely might appreciate, an occasional phone call from their child or from their friend or a visit from the neighbor. This is about intentional isolation that's perpetrated by a caregiver or someone who has authority and access over the person that we're talking about. A lot of people refer to this as like false imprisonment. It's not uncommon for APS, Adult Protective Services, to get reports from distant family and concerned friends, so-and-so never calls me back. I'm worried, are they okay? Or, every time I call, their adult son says that that they're sleeping or unavailable. And this has gone on for months and I don't actually know if they're okay. Sometimes that can result in police doing a health and safety check. And sometimes that may also and or otherwise include a visit from Adult Protective Services to assess the situation. Abandonment includes the desertion of an elder or dependent adult by a person who's assumed responsibility for providing care or who has physical custody of that elder or dependent adult. And just literally walks away or steps away from their duties and fails to make other arrangements if they are no longer able to do that. The public guardian or conservator, these are folks who manage both probate and mental health conservatorships. And a mental health conservatorship, you might hear people call it an LPS. It stands for Lantern Petrus Short Act. Conservatorships, these are adjudicated by the court for those who lack capacity to manage their finances and or healthcare, or to be gravely disabled by mental illness or substance abuse. The Public Guardian or Conservator's Office works together with APS to protect adults and dependent adults, elders and dependent adults who are victims of financial abuse or exploitation and who are unable to protect themselves. So just thinking about the role of APS, their role is prevention, involves prevention of abuse, investigation of reports, helping to create stable environments, and helping to remedy problems through referrals and short-term case management. So they have a lot of different hats. And some of you will be going into this work directly, maybe through your internships and or post-graduation. So I want to talk briefly about the legal authority for adult protective services is defined in the Welfare and Institution Code 15630. And Senate Bill 2199 was chaptered in 1988, which expanded the role of the mandated report and created a statewide mandated APS program. So if you look at, this wasn't that long ago. I'm aware as I say that, some of you might not have been born when that was written, and I can't think too much about that right now, but it's important to think about as compared to child protection, adult protective services is a much younger system, and it is also a lot less resourced, to be very honest with you. And we'll talk a little bit about that. There are increased penalties for failure to report under this bill that was passed, statewide mandated reporting of abuse. So both statewide requiring that there was an APS program and that there was mandated reporting, and a 24-hour hotline was established. You'll find that in some counties, the hotline for child abuse and APS are actually the same people answering that hotline. Some of you may have jobs where that's your role. So those are things to think about. In many places, they are separate hotlines though. Okay, and the legal authority in terms of what their role is defined in the Penal Code 368. So just like with Child Protective Services, we still have 58 counties in California. That has nothing to do with the programs, it's just about our state. So each county has their own APS program. Like with child welfare and child protection, the programs can differ a bit by county, but all have some sort of 24-hour capability. Rural counties may combine adult protective services and in-home health support services workers sharing cases and sharing duties. And there are, definitely geographical challenges in both large and more rural counties to access everyone who needs the support. And, the budgetary restrictions are significant in APS, and there are far fewer resources in APS than there are in CPS, and there are far fewer resources between the need and what we actually have available. And these are continued areas for social justice and areas of public policy reform that are absolutely necessary for those of you who dedicate more of your work in the policy and macro arena. Certainly these systems and considerations need our attention and support. In 2011, the state of California turned the oversight of APS back to the local government. And so that, again, has parity with CPS. County APS programs can vary significantly, as I said. The prevalence estimate is between 4 and 6% of the elderly in the United States are victims of elder and dependent adult abuse. In California, about 50% of cases are self-neglect, and over 30% are cases of financial abuse. So adult protective services, some best practices, the guiding value is that every action taken by the system needs to balance the duty to protect the vulnerable adult with their right to self-determination, right? And so this, again, is a very different mandate than the child protective services system. Again, because we're working with adults, there's a way in which we need to hold this role a bit differently. Secondary value is that older people and those with disabilities who are victims of abuse, exploitation, or neglect need to be treated with honesty, caring, and respect. So just because a person may not be able, again, to legally consent, we need to proactively seek their assent in terms of our interventions. And, to not infantilize older or dependent adults. Oh, they just don't understand, so I'm not going to waste my time trying to explain why we're here. They wouldn't get it anyway. Or realizing that you're not talking to the client directly, but you're talking about them and in front of them to other people. These are forms of disrespect that we definitely see, and sadly, I see it even with people with advanced training in social work and MSWs. No one is immune from this kind of behavior, and it's important to check yourself and to check how you're showing up in the work. Principles of APS are that adults have the right to be safe, to retain their civil and constitutional rights, unless some of these rights have been restricted by a court action, right? Like a court-appointed guardianship or probate conservatorship. Adults have the right to make decisions that don't conform with societal norms, right? People can make their own choices as long as these don't harm other people. Adults are presumed to have decision-making capacity unless a court adjudicates otherwise. Okay, so that really is a court decision, not about our personal opinion. And this is very important. Adults have the right to accept or refuse services. Okay, so unlike child protective services, where if we go to the door and a family says you can't come in, we could come back with, a police warrant to go into the house. And, just because a parent refuses to involve themselves in a investigation or an intervention or referral, that system would continue anyway. In adult protective services, adults have the right to accept or refuse our services. That is their right. So who are mandated reporters? Any person who has assumed full or intermittent responsibility for the care or custody of an elder or dependent adult, whether or not they receive compensation. So this includes volunteers, includes interns. This includes administrators, supervisors, any licensed staff of a public or private facility that provides care or services for elder or dependent adults, or any elder or dependent adult care custodian or health practitioner or employee of a county APS or local law enforcement. Health practitioners here are defined as associate clinical social workers and licensed clinical social workers, but not MSWs, which is one of my many policy rants that this law is still kind of emergent. This is a younger kind of system, maybe working with older populations, but kind of a younger system for development. And so I want to say that even if you are not assuming full or intermittent responsibility for the care or custody of an elder or dependent adult, and if you are technically not a health practitioner or otherwise named in this mandate, I want you to understand that it is absolutely considered a standard of social work practice that you are a mandated reporter for elder or dependent adult abuse, period. And so kind of like we've talked about with some other laws, like you might not be working with someone as a psychotherapist, but or you might not be working in a situation where your work is covered under HIPAA. These are considered, areas of consent, and following HIPAA guidance are considered standards of our profession of social work. So it's very important to understand that if you were to fail to make a report, that would be considered, to falling outside the guidelines of our professional mandate. Please be sure to talk with supervisors if you're ever not sure about what to do, or you're feeling conflicted, or or any of those things, because it's very important that you understand your mandate and that you execute it. So again, self-determination, we want to respect that in clients, except if a crime has been committed. A victim can refuse or withdraw consent at any time to an investigation or services by APS. Again, unless a penal code section has been violated. If someone has broken the law, not necessarily referring to the victim here, but if there's been a legal violation, then the person cannot fully refuse those services. If an individual lacks the capacity to give consent or is under the influence, then a petition for temporary conservatorship may be initiated, in which case that person would then need to follow the guidance of that conservator. And it's important for us, as social workers in general, but looking at this particular value around self-determination in particular, that we support people to receive services in the least restrictive environment possible, and to take the least restrictive measures possible. So if we can achieve our aims without, making major legal changes, then, that's, the preferred way to engage in the work. So criteria for reporting, reasonable suspicion. Again, this language is similar to child abuse reasonable suspicion. Would an objectively reasonable suspicion that a person would entertain based on facts that could cause a reasonable person in a like position, drawing when appropriate upon their training and experience to suspect abuse. And so, do you have, is this based on something beyond your gut, right? Is it facts? Would a reasonable person in a like position, so in your case, a social worker, would another social worker be apt to see it this way based upon your training and experience? Again, you don't have to be told someone is hurting me to have reasonable suspicion that a person may be experiencing abuse or neglect. And so we are held to that standard. Reporting is an obligation of each mandated reporter and shall not be impeded by any supervisor or administrator. Sorry for the word spacing on that. Okay. So failure of mandated reporters is considered a misdemeanor, punishable by not more than 6 months in jail or by a fine of up to $1,000 or both. If unreported abuse results in the death or great bodily injury, is punishable by up to a year in county jail or a fine of up to $5,000 or both. So there are these important elements in the law. This does have parity with failure to report child abuse. So how to report? I have a little bit of a pet peeve about this that I'm mostly going to keep to myself, but I want to say that, there's been a fair amount of critique in recent years about reporting elder and dependent adult abuse because they have created a couple of different tracks based upon the role that you have. So the nature of the allegations, if serious bodily injury is a part of the report, then we need to handle it in a slightly different way, which we'll talk about. We also need to think about where the alleged incident occurred. Is it in someone's own home? Is it in a licensed care facility? That the location matters. And also the identity of the mandated reporter. So what I highly recommend is that you access a reporting form, which is on B-Course. Please familiarize yourself with it. Like with a child abuse reporting form, my strong suggestion is that you've spent some time looking at these forms before you ever need to use them. The moment that you need to make a report is often fraught with a lot of stress, confusion, feeling pressure, feeling maybe anxious. Maybe it's your first one or one of the first you've done, and it understandably brings up a lot of feelings, and sometimes it's hard to take in information when we're under those conditions. So I encourage you to take a look at these things now while you're being prompted to do it, and to continue to revisit these, and to also have easy access to reporting forms because you never know when you're going to need them. Okay. So how to make a report? You need to make a report by phone immediately or as soon as practically possible to a county APS program where the client lives. Okay, where the client lives. And you will see a copy of both the form and a list of county APS program agencies. The written report needs to be made within 2 days to the APS program, again, in the county where the client lives. So 2 days, 2 calendar days. This is different than child abuse, which is 36 hours. So please make note of that difference. So now how to report. As I mentioned, there are both in terms of what the abuse or neglect might be, the identity of the reporter and the location of the abuse slightly changes how to make the report. So if you're making a report of serious bodily injury, this changes the timeline to making the report immediately and no later than 2 hours from when you became aware of it. Okay, instead of as soon as practically possible, because for you, and as soon as practically possible might be towards the end of your shift. And what the law says is that if it's serious bodily injury, you need to report it immediately. Stop what you're doing. If you need to get someone to cover your work so that no other people are left unsafe, do that and make the report in no longer than 2 hours from when it was brought to your attention. You initially make the report by phone or confidential internet reporting tool immediately or as soon as practically possible, and mail the written report within 2 working days. If the abuse occurred in a long-term care facility, like a nursing home, adult residential facility, adult day program, adult day health program, residential care, contact the long-term care ombudsman or local law enforcement. Okay, so this is a little confusing. If the alleged abuse or neglect occurred in a state mental hospital, as a mandated reporter, we need to contact the California Department of Mental Health or local law enforcement. If it occurred in a state developmental facility, like regional center of the East Bay type facilities, or regional center, any facilities in California, we need to contact the California Department of Developmental Service or local law enforcement. Now, this is a lot to remember, and you might be feeling really overwhelmed. What I hope that you will take away is, number one, follow the report, look at what's on the reporting form itself. Number two, if you need guidance, when you call APS and if what you're reporting needs to be reported to someone else, they will help you. They will tell you, oh, actually, you know what, you need to call, the California Department of Mental Health about this one. Okay. So they should help you through that. It should not be the situation where, if you call the wrong place, you're on your own to figure it out. But I do want you to be aware of this so that ideally you can try to make thoughtful choices about where you initiate your reporting. So that's the end of this section. Please avail yourself of the resources on B courses and continue to consult supervisors whenever you have questions. Any type of mandated reporting and notions of abuse and neglect among vulnerable populations can bring up a lot of feelings for us. So continue to notice what happens for you when you hear about these stories, when you find yourself in situations where you might need to report them, how that impacts you. Again, self-care is an important part of the work. And even though it's not uncommon for us to encounter these issues in our work, that doesn't make them any easier to kind of wrestle with internally, right? Sometimes we see things and we hear things that many other members of the population don't think about on a regular basis, and it can take a toll. So please do take good care of yourselves. Thank you very much for your attention, and I will connect with you in a future setting. Thanks a lot.